Okay, good afternoon. My name is Stan Komorik. I'll be chairing the meeting this afternoon. I'd also like to introduce my fellow committee members. On my far left is Natalia Popovic. On my left, Donald Taylor. On my right, Laura Alderson. And on my far right, Bill Dalton. Welcome. And just need to go through some opening remarks. So in accordance with sections 45 and 53 of the Planning Act as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning that apply to properties, permissions to extend or alter lawful nonconforming uses, and consents to sever property to create new lots. Our land acknowledgement, we acknowledge the land we are meeting on is a traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Just go over some hearing procedures. The committee hearings are now conducted in a hybrid and in-person virtual format. Some applicants and some participants will make their submissions in person. Others will participate virtually through WebEx. The meetings are also streamed on the City of Toronto YouTube channel, and anyone wishing to view the hearing may do so on YouTube. Those who want to participate virtually have been registered in advance will be connecting with their computer, tablet, smartphone, or telephone, and have the option of participating via video or audio only. All virtual participants will automatically be muted on entry. When your item is called, you will be unmuted by the moderator, one person at a time. We ask that you also mute your devices until you are called on to speak. Actually, Adam, you ask people not to mute and unmute themselves. So a bit of a contradiction. Any presentation or other materials you wish to submit to the committee must have been emailed in advance of the hearing. Staff and committee members cannot accept materials at the hearing. When addressing the committee, please clearly state your name and address. Please remember to confine your remarks to the matters outlined in the application. The applicant or agent will proceed first and will make a presentation to the committee on the application. Please note that the committee may not entertain revisions to the proposal at the hearing today. The committee may decide to defer the application if substantially revised to ensure that the revised application is accurate and that all those entitled to notice of the application are informed of the changes. Then individuals either in support or opposition to the application will be invited to speak. Generally, we first call on speakers in the hearing room and then those participating online. Committee members may ask questions of each speaker after they have finished their presentations. When all speakers are finished, the applicant agent has an opportunity to rebut only those issues that were raised by the previous speakers. This will mark the end of the discussion, and the application will then be taken into committee for our discussion and decision. Okay, that's all the formalities. And I negated to introduce our Secretary-Treasurer, Mr. Phil Carvalino, and Phil's staff who are here to assist us. And I guess the first order of business is, do we have any deferrals or closed files for the afternoon? Thank you. And do any members or staff have any conflicts of interest to declare on any of the items for the afternoon session? No, okay, thank you. So given no deferrals, we can start the order of the agenda, starting with item 19. And, item 19 is, and actually, can we 19 and 20 together? Okay, perfect. So let's do 19 and 20 together. So that's 10 and 12 CAVELL Avenue. This is an application to obtain consent to sever the lot for the purposes of a lot addition and to create an easement right-of-way. It is also, which will be done through a delegated process. It is also an application for the related variances that will come about with the proposal to construct 2 triplexes on the divided lots should they be divided. Just give me one more sec. Since we're dealing with these together, I believe on the first one there are 6 variances being requested to construct the triplexes, and on the on the first one there's 7 variances, on the second one there's 6 variances. We have forestry requesting a denial or in the alternative a condition 2. We have Metrolinx with conditions and advisory comments. We have transportation requesting 3 conditions in the event of approval. And we have ECS conditions and advisory comments. And this is, where are we? Number 19. David Engelman is the agent who is already at the microphone. Welcome.
Good afternoon, Mr. Chair and committee members. Thank you for having me. David Eagleman, Design Plan Services, Inc., 900 the East Mall Suite 300, associate and planner here on behalf of the owner. And through you, Mr. Chair, I anticipate perhaps a brief presentation.
I think you'd want to do a full presentation on this one.
Okay. Thank you, Mr. Chair. So through you, Mr. Chair, I did provide a detailed justification letter regarding this application. So I trust that the committee has reviewed that letter. But to preface my presentation, I will note that we have been dealing with this proposal for quite some time now. This application has been with the city for quite a long time, and it was previously deferred from the July 28th, 2022 Committee of Adjustment hearing in order to consult further with city staff. And even prior to that deferral, discussions were ongoing, so there has been extensive discussions with city staff regarding this proposal. Specifically, we consulted very extensively with planning staff, have made numerous revisions to the proposal, and we're pleased to inform the committee that planning staff are now in support of the application, have no concerns or objections, as demonstrated by their submitted correspondence in regard to this proposal. We have also consulted with transportation staff, and they have indicated that they have no concerns or objections, in addition to engineering and construction services, subject to their recommended conditions, which we are all agreeable to. And I have reviewed the comments from Metrolinx as well, and we are agreeable to their recommended conditions also. I have also reviewed the memorandum from Urban Forestry, in which they recommend refusal of the proposal. And specifically in regards to the proposed lot line adjustment, proposed easements, as well as variances 4, 5, and 6, which really all relate to the shared driveway. I respectfully disagree with the recommendations from Urban Forestry, and ultimately it is my opinion that the committee should approve this application despite Forestry's recommendation, and we are agreeable to the standard forestry condition that Forestry provided in lieu of taking their recommendation of refusing this proposal. I am not an arborist, so that is not my area of expertise, and I acknowledge that. However, I did review Urban Forestry's report, and again, their concerns relate to the proposed lot line adjustment, the easements, and variances 4, 5, and 6, which all relate to the proposed shared driveway. And Forestry specifically expresses concerns with trees number 1 and 2, which they identify within their report. Based on the arborist report and the tree protection plan we have provided, I believe the trees that Urban Forestry is concerned with are the same trees that our arborist refers to as trees number 7 and 8. Urban Forestry seems to make the assertion that we are proposing to remove both of these trees. However, our arborist has stated within the report that only one of these trees is proposed to be removed. The other is proposed for injury. However, based on our arborist report and the mitigation measures provided by our arborist, that tree that is proposed to be injured is not intended to suffer any long-term adverse impacts. And I'll further state that it is my opinion that these two trees are within the as-of-right building envelope. They don't relate directly to the proposed driveway, the lot line adjustment, or the easements in any particular manner. These two properties exist as two separate properties already. They can be redeveloped with residential dwellings today as of right, and you can have driveway locations that would ultimately result in the removal of those trees as of right. So my opinion is that those trees are within the as of right building envelope, and I don't think those trees relate to the variances, lot line adjustment, or the proposed easements as part of this proposal. So that was, I'll also note that we obviously have to go through urban forestry if the committee chooses to approve this application. We will still have to go through the forestry permit process. And lastly, I'll point out that we have consulted with adjacent and surrounding neighbors regarding this proposal and have obtained and submitted 14 signatures in support, which again have been provided to the committee. So I know I'm running out of time. I did address the variances in detail within my justification letter. I'm happy to answer any questions, but it is my professional opinion that this represents good planning, meets the 4 tests under Section 45(1) of the Planning Act, as well as the criteria for consent under Section 5124.
Thank you. I do have a couple of questions, and I just want to kind of summarize. You can chime in whether I'm correct or not, this application. Essentially, what you're proposing here is to take two current semi-detached dwellings and put a driveway down the middle between the two and create two detached dwellings.
Through you, Mr. Chair, correct. However, the two dwellings are triplexes. So they will...
I see. So they're already triplexes now, and you're looking to...
No, my understanding is that they are semi-detached units, so they're currently one dwelling each. We're tearing down the existing structure, which is a semi-detached building, and we're proposing two new triplexes.
Understood. But you said that they already are triplexes, but a triplex is not a legally permitted use within a semi-detached house. So how do you explain that?
No, sorry, sir, if I was unclear. Through you, Mr. Chair. It is an existing semi-detached building with one dwelling unit on one side and one dwelling unit on the other.
So that's what I said. You're taking two semis, tearing them down, putting a driveway down the middle, and trying to construct two triplexes on the two new lots.
Correct.
Okay, that's all. I just wanted to confirm that. With regard to your petition in support, I find it questionable when I see people's names listed that live over a kilometer away from the site. So it's not, doesn't turn my crank one way or the other than I find it questionable to have those people on that petition. It doesn't, to me, it doesn't add to the presentation at all. The other thing I forgot to mention is that there is an objection from number 14, and I'm not sure if you want, or if you have if you could address some of the concerns spelled out in that objection letter.
Yes, through you, Mr. Chair, I did review that objection letter. I'll just pull it up now, and I'm not sure if that neighbor will be speaking today, so perhaps I can address their points when they speak, if they do speak. But my understanding is that really the main concerns are with the FSI variance, with the parking. However, these are triplexes, which are considered multiplexes under the new amendments for multiplexes. The FSI is really being sought out of abundance of caution. Again, this was going through the process for a very long time. I spoke with the zoning examiner yesterday regarding the FSI. My understanding is that really we don't need the FSI variance because multiplexes are no longer subject to FSI. However, because the zoning review was conducted when it was, we are seeking to get it. And regarding the parking, no parking is required. We are providing some parking spaces, 2 on each lot, just to provide for some parking on the property, and that's shared between the 2 triplexes. And, you know, in my opinion, Mr. Chair, and based on the justification I provided within my letter, it is my opinion that the variances are minor and that this is a good application that provides a density in a neighborhood with a multitude of building types.
We get that. We get that. So my other question has to do with, it was very difficult for me to determine your parking plan because you've got a site plan which is so jammed full of stuff that it's hard to determine where the new driveway is going, where the parking spots are. I don't know, can we put that up? Maybe you can explain that to some degree.
Mr. Chair, can you repeat what you'd like to see up?
I'd like to see where are the parking spots on that? On the site plan.
Yes, through you, Mr. Chair.
I mean, you can eventually figure it out, you know, when you kind of decipher it, but it's not very clear.
Understood, Mr. Chair, and I appreciate the comments. I do understand it is fairly packed site plan, but if you just zoom in at the back there, so on this would be the plans for 12 CAVELL. So you can see there's 2 parking spaces marked with X's, and they have sort of a unique pattern to them. That's to indicate the permeable pavers. Those are the 2 parking spaces. And on the 10 CAVELL site, they're similarly marked with X's, and on the 10 CAVELL site plan, they're also similarly.
Where does the right-of-way terminate? Is it going to terminate at the end of the property, or?
Yes. So through you, Mr. Chair, if you can see sort of the outline. It sort of comes in straight through the back, then tapers outwards, and then tapers back in towards the rear lot line.
Yeah, it just would have been helpful to do a separate site plan showing the parking situation only. Was it on the draft R plan?
Yes, perhaps it's more clear on the draft R plan. So
there we go.
Yes, through you, Mr. Chair, you can see there the tapering in and out of the driveway, which is also going to be the easement.
Okay.
Subject to the easement.
So it's not like the old rights of way which terminated at the back of the house. This is going right through.
Yes, and we wanted to provide a little bit of a hammerhead for turnaround, so that's why it sort of tapers at the back there.
Okay. Perfect. Thank you.
Great. Thank you, Mr. Chair.
Is there anyone here to speak on this item?
Mr. Chair, nobody in chambers and nobody online.
Okay, perfect. So now, how do we deal, since the severance is delegated and the variances are ours, how do we deal with that, Phil? And you'll provide yours? Okay. And then we all get together. Right. Okay. Yes, please.
Thank you, Mr. Chair. Mr. Agent, I'd like you to expand a little bit on the concerns from your client's perspective that forestry raised, because the same or a similar concern is raised in the letter of opposition. I realize no one's here, but that the tree issue has been raised again by the opposing neighbor. So could you elaborate on why healthy trees have to be removed? And I know you've mentioned we may not be talking about the same trees, but clearly urban forestry has some concerns.
Yes, through you, Mr. Chair. Ultimately, I'm not an arborist, so it's not my area of expertise. However, there are two trees in front of the property, and they effectively they're there, and we have to deal with them. Whether the properties are redeveloped with the proposal that's in front of you today or with an as-of-right proposal, my view is that those trees may have to be removed anyway. So my opinion is that, unfortunately, those trees are just within the as-of-right building envelope, and redevelopment of the property in most ways would necessitate the removals of those trees. But again, forestry seems to assert that we're removing both of the trees that they're concerned with. Based on our arborist report, we're only removing one of them, and we're trying to preserve as many bylaw regulated trees on site as possible. So those are really my comments on it. I can't speak to it further other than that it's within the as-of-right building envelope.
You have a difference of opinion with forestry
Correct.
at the end of the day. Thank you.
So which tree is being removed? One or two?
So through you, Mr. Chair, I will just confirm that it's a little confusing because forestry refers to them as 1 and 2, and our arborist refers to them as 7 and 8. But let me just confirm.
They're both white ash. One is 44, the other is 42 centimeters.
Yes, so the tree number 1, that according to forestry's report is the one on the left-hand side when you're looking at the properties on in front of 12 CAVELL, and tree number 2 is the one in front of 10 CAVELL. And so according to our arborist, we are only injuring the one in front of 12 CAVELL, and the one in front of 10 CAVELL is the one being removed. Thank you.
Okay, any more questions or no? Okay, thank you. So we take it into committee, and if anyone has any comments or if they're ready for a motion? Both, yeah. So just as a reminder, we have ECS conditions, we have transportation conditions, and forestry conditions all being requested in the event of approval. Phil, do we hear from you at some point, or how does that work? You want to hear from us first, eh? Okay. Yeah, I mean, it's the severance and the lot additions make sense if this is what you want to propose. Yeah. Yep. No. No, and adding an easement down the middle. Yeah. Yeah, yeah, and I'm glad that it's not, the old style easements that, terminate and then create problems at the back, so.
Okay, I'd like to move a motion for approval because I think the applications meet the 4 tests. And this is for 19 and 20, subject to transportation services, 3 conditions, ECS's 4 conditions, tree protection conditions. And that's it, right? That's right. There.
Yep. So we have a motion on the floor. Moved by
Aye.
Mr. Dalton.
I'm happy to second that motion.
Okay, Ms. Alderson, all in favor? Okay, I think you have unanimous approval. Thank you. No? You dissent? I'm sorry. Okay.
Yes.
Okay, so we have a 4-1 vote on approval. Thank you. Item 21. 3955 Warrender Avenue. This is an application for consent to sever a lot into 2 lots and to create easements and rights of way. ECS has conditions and advisory comments, and planning and transportation have both chimed in as being okay with the application. Stephanie West is the agent.
Yes, hello, I'm here.
Hi, good afternoon. If we can get
Good afternoon.
if we can get a presentation on this one, please.
Sure, thank you. And good afternoon, Mr. Chair and members of committee. My name is Stephanie Quast, and I'm a partner with Bousfields, and we are the applicant to the owners of the property located on the south side of Eglinton, west of Kipling, and municipally known as 39 to 55 Warrender Avenue. Through this submitted consent application, we are looking to sever the 55 Warrender property from the larger apartment block, and in doing so, establish easements related to servicing and access in order to ensure that the 2 properties continue to function properly and without interruption. So today there are 3 apartment buildings on the entirety of the site, but on the 55 Warrender property specifically, there is a recently constructed 16-story rental apartment building. 20% of the units within this building are CMHC affordable rental units. And this building was constructed in partnership with the federal government's rental construction financing initiative, which was administered through the CMHC. A loan agreement secured over both the 55 Warrender property and the larger apartment block was signed by the owners and the CMHC in July of 2018. So now, in order to comply with the provisions of that loan agreement, the 55 Warrender property is to be severed from the larger apartment block so that the CMHC loan applies solely to the 55 Warrender property, which is the parcel there in red. So through this severance, and in order to ensure that the 2 properties continue to function properly and without interruption, easements related to servicing and access need to be established, and these easements have been identified through this application. We have reviewed the requested severance under the relevant sections of the Planning Act, and it is our opinion that this application satisfies the relevant criteria. As such, we are seeking approval today for this consent application. So thank you for your time, and I'm happy to answer any questions that you may have.
Thank you. I'm assuming there's no one here in the room to speak to this one?
Mr. Chair, we don't have anyone on our list to speak in the room, nor is there anyone online to speak.
Thank you. Any questions from panel members of the agent? No? Okay, so we can take this into committee if there's any discussion or if someone's ready for a motion.
Mr. Chair, if there's no discussion, I'm prepared to make a motion.
Okay, thank you.
Thank you for the presentation. I believe that the application satisfies the 4 tests. I see that staff have planning, engineering, and transportation have no objections, and on that basis, I propose approval.
Okay, there are engineering conditions.
A condition, excuse me, 2 conditions. 2 conditions.
Transportation is okay. No.
I'll second that.
Okay, seconded by Bill. All in favor? Okay, unanimous approval. Thank you.
Mr. Chair, before we get on to item number 22, I would like to let you know I didn't get a chance to microphone check this particular agent as they kind of got into the meeting a bit late. They have also asked to be on video, so I'm going to go ahead right now and open up and
please.
ask them. Thank you. Andrea Patterson, firstly, a microphone check. Andrea, go ahead. Andrea Patterson, go ahead. Well, Mr. Chair, it's a good thing we microphone checked them. Andrea, are you there? Andrea, do not mute or unmute yourself. City staff will be responsible for that. Andrea, go ahead. Okay, Mr. Chair, I don't think Andrea has authorized the use of a microphone. With that being said, what I'm going to try and do is maybe we'll bump them over. They've asked to be on video, so I'm going to bump them over to make them a panelist. Andrea, I've made you a panelist. You may be able to activate your microphone now and start your video by clicking the Start Video button at the bottom of the screen. I see you there, so I'm going to bring you onto the stage. Now, can you just say hi or hello or anything? Well, you can hear us, but we can't hear you. Okay. Oh, you're muted still. No, are you muted? Hello? No, so she is, yeah, we got her unmuted on our end, but yes, you need to go, we'll log out and log back in and make sure you authorize the use of your microphone. We'll stand this item down for a moment. If that's okay, Mr. Chair, we'll get her to log back in and we'll figure that out. Andrea, it might be the headphones. I know they probably have a built-in microphone, but that could be the issue. We'll go from there and see, but we'll stand this item down for a moment, and then we'll come back to it, Mr. Chair. Thank you.
Okay, thank you.
No, so I guess on that note, we'll go to item 23,
23.
3526 Lakeshore Boulevard West.
Yep. Okay, this is a application to alter the established grade and to reduce the number of proposed parking spaces for a mid-use development currently under construction. There are 2 variances being requested. Transportation is requesting 6 conditions in the event of approval. Metrolinx has advisory comments. Forestry or Ravines is asking for 6 conditions in the event of approval. And where are we? 23. Mr. Robert Blunt? Perfect. Okay.
Hello.
Welcome.
Welcome. I'm here on behalf of the landowner, Minto. And as you can see, there are 2, I'm going to call them technical variances. Relatively recent bylaw approved through the OLT a couple of years ago, but it's a process I think has been going on since 2019. So with the first variance, with the grade, if you actually look at the bylaw, there's about 8 or 10 different grades established through the property. So it's actually just one of the grades, one piece of the grade puzzle that we're requesting a change. And I believe the change is roughly a meter difference, yes.
Okay. And then there's the second variance is a reduction in parking spaces.
Yes, again, and that's one of those where the bylaw chops up the property and assigns different parking ratios to different parts of the property. So we're requesting for one part of the property, these blocks 1 to 7, a reduction in the parking ratio.
Okay.
And of course, the background is, the city is looking to eliminate parking ratios for one, but the client isn't looking to eliminate, they're trying to reduce the quantity of parking.
And you're fine with the numbers stated in because I know that transportation refers to a formula, whereas the variance refers to the number of parking spaces. You're okay with the 278 parking spaces?
Well, it's a bit of an interesting story. The bylaw obviously has the ratio. I originally submitted the variance to match the ratio that engineering services had provided. The ratio, the number, both were.
Okay, so that ratio does produce that number.
No, actually, the ratio produces a slightly smaller number,
Okay.
which I regret I didn't asked for originally.
But you're okay to provide the 278?
I would prefer if it was 275, which matches the ratio.
But then we could potentially have a notice issue.
Sorry?
We could potentially have a notice issue if you go to
But
275.
potentially. So I'm saying we would agree.
So
no
you're willing to
concern.
accept the 278?
Reluctantly, I dropped the ball and should have said 275.
Okay. I mean, your other option is to do a deferral and we go for the 275.
No, I know we'll be back in 2 or 3 years when the garage is finished and the 278 are produced and 3 spots are substandard. That's sort of the wiggle room, the 278, the 275. So if it's 278, we'll be back.
I don't think anyone really cares that much, but we don't want to get into the having a notice issue, so.
Oh, I agree. The irony of the ratio is actually 275.
Fair enough. Any other questions? No? Okay, is there anyone here for this item? I'm assuming not. Okay, Adam, no one online?
No, Mr. Chair, no one's online and no one's in the
Okay, thank you. But we'll take it into committee and thank you. Anyone ready for a motion, a discussion or motion?
I'll make a motion unless anyone wants to discuss. Yeah, thank you. Okay, thanks, Mr. Chair and colleagues. Yeah, I find this application to be quite appropriate and acceptable. It meets the 4 tests under the Planning Act. I would move approval subject to tree protection and plan reviews, 5 post-approval conditions. They included another condition and said that it had already been complied with. So the 5 post-approval conditions. And the transportation services conditions with an amendment, there are 6 of them. I'm moving approval subject to an amendment to the first 4 of their conditions, all of which talk about amending the OLT bylaw. I'm going to suggest or move that the word amended be changed to varied, because this panel does not have the authority to amend a bylaw, but it does have the authority to vary or approve variances from. So I hope that's clear, and that's my motion.
Thank you, Mr. Taylor, for a well thought out motion. Is there a seconder?
I will second that.
Ms. Popovic, thank you. All in favor? Okay, unanimous approval. Thank you.
Thanks.
Mr. Chair, I see that Andrea Patterson is back on for item number 22. Should we give her a shot?
Absolutely.
Perfect. Andrea, I'm going to move you to a panelist. So you can go ahead and start your camera. Okay, I see you there. And let's just see if we can test slow. Say hi. Let me know what you had for breakfast today. Maybe that'll help. No, I still can't. We still can't hear you. We can see you, but we still can't hear you. Yeah, you can call in then. Okay. All right, Mr. Chair. So we'll stand this down one more time, and we'll get Andrea set up, and we'll look. So we'll look to go on to item number 24. Correct. We'll look to get on item number 24.
Okay, item 24, number 37, Sagebrook Crescent. This is an application for a 2nd-story addition above the existing dwelling and a 1-story front addition and a east side yard covered patio. There is a request for 1 variance, and that is for FSI. We have advisory comments from TRCA and advisory comments from Ravines and Natural Forest Protection. And Sheen Tossi is the agent. Sean?
Good afternoon, Mr. Chair and members of the committee. My name is Sean Tusi. I'm the office principal at MANOR Architects, Inc., representing the owner today for this application. The address for the report is 2323 Yonge Street, Unit 503, Toronto, Ontario, M4P2C9.
Thank you, welcome. Not sure if we need a complete presentation, but if you want to just hit some highlights, and then we'll see if there's any questions.
Sure, Mr. Chair. I'll just do a very quick version. It's a standard two-story addition over an existing footprint, so we're not really changing the width or length or anything for that matter. The second floor addition is causing the extra square footage. This drawing really shows sort of very good. This is a lot, and because it is in a ravine, if you look at the FSI, with the actual lot size, which is what you typically get if it was not in a ravine, the new proposal will be only 31%. So we're technically less than the permitted FSI, but it is really just a technical variance where the way they measure it, if the lot is in variance, they will measure it slightly different, causing the variance to come in. So as a result, we think this is a fairly standard addition. It meets the 4 tests of bylaw. The variance is really a technical variance, and as a result, we respectfully request your approval. Any question, I will be happy to answer.
Thank you. Any questions? No? Thanks very much. There's no one here to speak for this item.
That is correct, Mr. Chair. There is no one online, and there is no one in the chambers to speak.
Okay, we'll take this one into committee. If anyone's ready for a motion, or we need some discussion.
Okay, if there's no questions, I'd like to move a motion to approve this application. I think it aligns with the 4 tests, and then as well as subject to the conditions in the TRCA letter.
They're just advisory action.
Okay.
So urban forestry is just advisory?
That's my understanding.
Yes,
I believe TRCA, though, has conditions.
but we don't impose that.
No. But that's up to the applicant to get the permit, so we'll just make the applicant aware of them. So no conditions. Okay, Mr. Dalton's moved. Second by Ms. Alderson, all in favor? Okay, unanimous approval, thank you.
Well, Mr. Chair, we've got Andrea on the line, on
Andrea's
a call-in now, so we'll give her a shot, and we'll see if this works. Microphone check for Andrea Patterson. Andrea, go ahead.
Can you hear me?
Yes, we
Hey,
can.
hi.
Excellent. Thank you.
Welcome.
Oh, yay. Okay.
Sorry
Okay.
for all the
Thank
confusion.
you very
So-
much. And
So now that
I
we've got you, if
appreciate
you can
your
hold on,
patience
if
in
you
this.
could hold on for 2 minutes while we do an intro on the item. So this is for 299 the Kingsway, also 9 and 11 St. Stephen's Crescent. It is a application for consent to sever the property into 3 lots. And ECS has conditions of approval as well as advisory comments. We have a part lot exemption report, and planning is okay. And maybe we can get an explanation that if you've already received consent through part lot, why are you here?
Yes, Mr. Chairman, through you, I'm happy to explain that. I am Andrea Patterson. I'm a land use planner at Denton's, and I'm here today on behalf of Alia Corporation, who is the beneficial owner of the subject lands. The purpose of this application is to make permanent the creation of 3 separate lots that were previously created through a part lot control exemption that will expire in June 2024.
Okay.
The subject lands, as you've identified, have the 3 municipal addresses, 299 the Kingsway, 9 St. Stephen's Court, and 11 St. Stephen's Court. For general background, these lands were originally part of a larger development parcel, which received zoning and site plan approval back in 2019 for phased residential redevelopment. Based on these previous approvals, much of the development construction has already been completed. With respect to the subject lands, which you can see in yellow, that light blue, and the pinky purple, 299 the Kingsway, which is the yellow, and 9 St. Stephen's Court, which is that periwinkle blue, have already been developed with a residential rental building on each site, both of which are already occupied. 11 St. Stephen's Court will be developed with a future residential condominium in accordance with the existing zoning and site plan approvals. The application before you today merely requests that the lots previously created through part lot control exemption be made permanent. And the reason for this current consent application is that despite the creation of each of these lots and related easements through the part lot control exemption, Aaliyah Corporation still retains beneficial interest in each of the lots. So any transfer occurring after part lot control exemption expires would require consent. So that's the consent that is before you for your consideration today. The application before you is identical to what was approved under part lot control exemption. Do you have any questions at that point? Yes. I did want to speak to the urban forestry condition, if I may.
Is there an urban forestry condition? Oh, I missed it. Okay, sorry. Yes, go ahead.
With respect to that condition, they requested submission of a completed application for permit to injure or remove a city-owned tree, and then the same for privately owned. Given that site plan approval has already been granted for the development, and that 2 of the new lots have already been developed and are already occupied, and that a condominium application will ultimately be required for the development of the 3rd lot, it's our request that the urban forestry condition not be imposed as a condition of consent, since permission for tree removal has already been dealt with through these previous approvals, and that any future application for condo will provide opportunity for such a condition if it's still deemed necessary. We're in agreement with the ECS conditions, and in fact, they've already been satisfied, but we're fine with those, and note that planning doesn't have any concerns.
Okay, thank you. We understand your request. I'm assuming there's no one else to speak to this item? No? Okay.
That is correct, Mr. Chair. No one online and no one in the chamber.
Okay, so if we can take that into committee to discuss the applicant's request and see where we go. Mr. Dalton?
So if there are no questions, comments, no?
Sorry, I just have one.
Yep, okay, go ahead.
Andrea, I'm sure you've sorted all this out, but I'm going to ask anyway. You're going to make sure, I presume, that you convey to separate and distinct entities so that you do not merge title and have to come back here again. Am I correct?
Oh, yes.
Thank you.
So with that, I'd like to move a motion for approval. I think the application meets the 4 tests subject to ECS conditions, and I think we have to impose the forestry. I'll confirm with Phil on that. Phil?
If Ms. Patterson is correct and these are redundant, they will be cleared quickly. But having the division request the condition, we don't have any way to confirm whether or not they're redundant. So if you impose it, it's easy to clear afterwards.
Okay. Then do it that way.
So we have a motion on the floor?
Yeah, there's no downside, and there may in fact be an upside. So I'll second that motion.
Okay, all in favor? Okay, unanimous approval. Thank you, Ms. Patterson.
So, Mr. Chair, after all that bouncing around, we are on to item number 25. 10.
25, okay. 10 Venice Drive. This is an application for a 2-story rear and side addition, including an attached garage to be constructed. To be considered as a new dwelling application. I guess because of the extent of walls that are coming down. There are 4 variances being there were 4 variances requested. That has now been reduced to 3, and one of those 3 has also been reduced. Forestry is requesting condition 2, and an arborist report has been provided by the applicant. The applicant for this, or the agent for this item is Joe Dome. I'm assuming Mr. Dome is online. Thank you. Joe? You there?
Yes, good afternoon. My name
Good
is
afternoon.
Joe Dome, 133 Torresville Avenue, agent for the owners.
Okay, can we get sort of a brief overview of what's being requested? And maybe you can explain the revisions and how they came about.
Yes, the owners would like to construct 2-story front, rear, and side additions, which will be considered a new dwelling, as mentioned, due to less than 50% of the main walls being retained. There are 4 variances currently were proposed on the public notice. However, more accurate grading was provided to the zoning examiner, who sent an updated zoning notice, which eliminates the first floor height variance and lowers the overall height variance from 10.49 meters to 10.2 meters. Both the revised drawings and the revised zoning notice are on file. Nothing is changing about the design of the dwelling, only the measurement of height due to grading. In accordance with the updated notice, so we would like to eliminate variance number 3 and amend variance number 2 to 10.2 meters.
Perfect, thank you. Any questions from panel members? No? Anyone here to speak to this item? No? Okay, we'll take that into committee. Any discussion or someone ready for a motion?
Any comments, questions? If not, I'd like to have a motion for approval. I think this application is pretty straightforward, meets the 4 tests, subject to forestry, condition number 2.
Mr. Chair, I will second it.
Ms. Popovic, thank you. All in favor? Okay, another unanimous approval. Thank you, Mr. Dome. Keep going. Okay. Item 2622, Lorraine Gardens. This is an application for a new detached dwelling with an attached garage. There are 4 variances being requested. Forestry was recommending denial, or recently in the ad, they have now chimed in saying that in the alternative, they would be accepting conditions 2 and 1. Planning has set out a condition of approval should we approve this. Transportation has chimed in as okay. 26. Just gonna flip my.
Mr. Chair, while I have a moment here, I'd like to bring to everyone's attention that those new forestry comments are on file. They just came in late because they were accidentally left off the original email.
Okay. So we can't blame forestry for that one. It was them, okay. All right, so we can. Okay, Peter Gerardo is the agent online. Mr. Gerardo?
Yes, good afternoon, Mr. Chair, members of the committee. Peter
Giordino, sorry.
David Small Designs. No problem. David Small Designs, 1405 Cornwall Road in Oakville. We're the authorized agents and designers.
Okay, I don't think we need a full presentation, but if you can just perhaps hit some highlights and then we'll see if there's any questions.
Absolutely. Can I ask at least for slide number 8 from our presentation? Just jump straight to 8.
We will jump straight to 8. We have a bit of a lag with our presenter's computer, so we will go to 8 as soon as possible.
Perfect, that's great. So we're happy to see that city planning, transportation, their planning reports expressed no concerns with their application, but we see that there was a request for denial from forestry. We're quite surprised to see that. We were just notified of that last Friday. We jumped straight into reaching out to Max Dita in forestry, who connected us over to Svetlana. We found out that the request for denial was because of 4 specific trees, 2 that are existing at the front of the property where the driveway entry coming in and going out are, and then one where the pool in the rear was, one that was right smack in the middle of our house. So that we were very surprised to hear. From Friday to today, just a few days, we made some modifications. You will find a modified site plan and a modified arborist report. We shifted the pool to get it out of the requirement for removing tree number 23 in the rear of the property. We spoke to Svetlana. She's pretty good with tree number 18, which is on our footprint. It's a second floor directly above that. And then the two trees in the front, we've modified our application to show those two trees as remaining. Although I will mention that if you did a site visit in front of our property, you will see that one tree is tilted about 20 degrees. The other tree is also tilted. So we have a little concern of the ability of those trees to, they're spruces, and we're a little concerned of the health of those trees. Anyway, that being said, we think we can deal with the forestry comments through the building permit application procedure. Those two trees in the front, they actually, sorry, I will mention that they did post the new comments, as Adam had mentioned, just this morning. We noticed this morning that the forestry denial is now linked to the driveway width. Forestry has concern with the driveway width, planning doesn't, transportation doesn't. We're effectively keeping the driveway as it is. Can I get you to flip just to the next page, please? On the slide, you'll see the driveway conditions there.
We're, as you can see, that the black screen is, we're trying.
Yeah, no problem. Yeah, okay. So here you can see the gray represents the proposed driveway. There is a dashed red line that is the existing driveway. You'll see that we're not really modifying it in any great degree. We're positioning the house further back on the property. So we're extending the driveway. We're maintaining the variance for the driveway is effectively the existing width of the driveway that's there right now. Anyways, we believe that the driveway variance is pretty self-explanatory. The other three variances were all related to height, building height, and then height of walls. We worked with planning to ensure that they were good with the proposed building height. They supported our application through our discussions with them, and staff reports don't have any concerns with building height, and those are the other three variance items. So that's the driveway and the three building height variances. Those are our four variances. I will mention that the house across the street at 21 Lorraine Gardens was approved in August of 2020 with a building height of 10.4, a wall height of 8.1. So that's just a direct comparable. That being said, I think the as of right diagram that was posted at the beginning shows that we're being respectful with the proposal compared to the limits of development on this property that are possible. You'll notice that we're nowhere close to side yard setbacks, FSI, or coverage limits on this property. As such, we draw the conclusion that the application represents good planning, responsible and minor in nature, and meet all four tests of Section 45 of the Planning Act. Thank you for your time. At this time, I'm prepared to answer any of your questions.
Thank you, Mr. Giordano. Do any panel members have questions? No?
Just a comment. I've seen the spruce trees on Street View, and you're absolutely right. They are on quite an angle, the ones on the driveway, beside the driveway.
Okay. Is there anyone here to speak to this item? I'm assuming not. Okay. We'll take it into committee then. If there's any comment or someone ready for a motion. So we've got planning requesting conditions tying to site plan with respect to the driveway, and forestry looking for conditions 1 and 2.
I'd like to move a motion for approval. I think the application meets the four tests subject to the conditions outlined in the planning and forestry memos.
Seconder?
I'll second, Mr. Chair.
Thank you. All in favor? Okay, unanimous approval. Thank you. So item 27 is 290 and 292 the Kingsway. This is an application to create one additional dwelling unit in a portion of the basement of each existing apartment building. There is only one variance being requested, and that's it. And there's no comments from anybody. Okay. Applicant or the agent is online? Yes? Okay.
Good afternoon,
Amir?
Mr. Chairman, members of... Yes.
Hello?
Hello?
Hi, can you introduce yourself, please?
Yeah. Good afternoon, Mr. Chairman, members of the committee. Thank you for having me. My name is Amar Hamsi, the applicant and agent for representing the landlord.
Okay, can I?
Would you like to?
Yeah, probably not. I just have one question, and I'm going to see if panel members have any questions. How many new units are you actually creating?
We're creating one unit on each building, which means 2 units.
So a total of 2.
Yeah.
Okay. Thank you. And there's comments from Ravine I forgot to mention. Is there anyone else? Does anyone else have any questions or no comments? Okay. Thank you then. Anyone ready for a motion?
Sure.
While I'm looking at you.
I'll move a motion for approval. I believe the application meets the 4 tests and there are no conditions. It's pretty straightforward.
Yep.
I will
Seconder?
second that, Mr. Chair.
Okay. It's unanimous approval. Thank you. Next page. One more and then we'll look at a break. Okay. So item 28, 7 Park Manor Drive. I just want to pull this one up.
While you get into that, Mr. Chair, I'll bring to your attention that there is one area resident in the chambers and one area resident on the line.
Perfect. Okay, so this is an application to construct a new detached dwelling with an attached garage, a new front porch, and a covered patio in the rear yard. There are 2 variances being requested. Excuse me. Planning is recommending refusal. Forestry is requesting condition 2. And we have 4 people on a support petition. And I see Mr. Engelman in front of me, so I'm not even going to look up who's the speaker. Welcome.
Yes, good afternoon again, Mr. Chair and committee. Long time no see.
Yeah.
David Eagleman, Design Plan Services, Inc., 900 the East Mall, Suite 300, here on behalf of the owner. And through you, Mr. Chair, given the comments from planning, I anticipate a presentation is necessary.
Please.
Yes, thank you, Mr. Chair. So through you, again, similar to the last application, I provided a detailed justification letter. So again, I would trust that the committee has reviewed that. I respectfully disagree with the recommendations from planning staff. I will get into that as I speak to the variances, but before getting into that, I will note that I have reviewed the memo from Urban Forestry. We are agreeable to standard condition number 2. And other than the comments from planning staff, I am not aware of any concerns or objections from any city departments, relevant commenting agencies, or any surrounding neighbors. Perhaps that would change depending on, I'm not aware of any concerns from neighbors. I don't know if the neighbors here today are here to raise concerns, but we have obtained signatures in support from both immediately adjacent neighbors at 5 and 9 Park Manor Drive. So regarding the two variances that we're seeking here today, lot coverage and FSI, regarding the lot coverage specifically, that includes both the rear patio and the front porch. So those two elements account for an additional 2% of lot coverage. So if you exclude both the front porch and the rear deck, we would be at a lot coverage of 37%, which is a 4% increase over what's permitted as of right, or a total of 21.72 square meters or 234 square feet more than what is permitted as of right. But even including the rear deck and the front porch, that's a 6% increase, which amounts to 31.84 square meters or 343 square feet. The rear yard setback being proposed is 1.7 meters larger than the minimum requirement, and the front main wall is also aligned with both immediately adjacent dwellings. So the dwelling is sited very much in keeping with what the intent of the bylaw is, and further, the proposal is compliant with all landscaping requirements. So it is really largely within the as-of-right building envelope, save and except for the coverage and the FSI. And regarding the FSI, that's an increase of 0.2 times the area of the lot. It will be distributed over 2 floors. The dwelling has a sloped roof design, which is consistent with the existing character. And the ceiling heights are 10 feet and 9 feet respectively. And apologies, I see the clock is not running, so I'm not sure how much time, but I don't have much longer anyway. I think I will be within the 5 minutes. And I would like to bring the committee's attention to the various photos I provided. Thank you for bringing that up. These are renderings of the dwelling. I will acknowledge this street specifically has remained relatively stagnant. There is not a lot of development on Park Manor Drive itself. It is mostly made up of post-war bungalows. However, there is new development within the neighborhood. And the various photos I provided are lots just on the immediate street to the west and the immediate street to the east. That would be Meadowbank Road and Warwood Road. And as you can see within the pictures I provided, there are many dwellings with similar massings and built forms as compared to what is being proposed today. And I will note too that those lots on Warwood and Meadowvale, they are larger, or Meadowbank, thank you. They are larger, however, they are larger by lot depth. But lots in this neighborhood have very consistent lot frontages and also front yard setbacks. So when you're walking through the street within the neighborhood, from a perception point of view, these larger dwellings on these larger lots with larger lot depths they're perceived in a very similar manner as how this new dwelling would be perceived. So I did also provide a number of similar FSI approvals within the broader neighborhood. And so it is my professional opinion that this proposal meets the 4 tests under Section 45(1) of the Planning Act.
Okay, thank you, Mr. Eagleman. I guess we'll get you to step down, and I think we have someone in the room who wants to speak to this item. Carmela? Welcome.
My name is Mr. Chair, esteemed members of the committee. Okay, which tells you how unprofessional this speaker will be relative to the professional speakers that you've had till now. Again, my name's Carmela Giardini. I'm here with my husband, Albert Giardini. We have lived at 42 Warwood Road for almost 30 years. It'll be 30 years in May. Our backyard abuts 7 Park Manor, but we share a fence because of the irregularity of the community with 5 other neighbors. So to say that Park Manor is the same or similar to the homes on Warwood or Meadowbank is not exactly true, because our frontages are something like 76, 73. Very few of them are 50. on those two streets abutting Park Manor. So we just got home from vacation on Tuesday night, opened our mail, and discovered this. So I apologize. I haven't had a lot of time to do any research, but I've done a little bit. And one of the things that really surprised me in reading the documentation is that, I'm sorry, I'm quite nervous. I'm not used to addressing such a committee. City planning staff has recommended that this variance be refused. So I asked myself, as an inexpert person, why would the experts be refusing this application? I come up with 3 main points with an additional small process one. First of all, I don't know your jargon. I don't have the same acronyms and I don't use them appropriately, so I offer an apology right up front. But as you know, this property is designated as neighborhoods in the Toronto's official plan, and I won't read it for you. I know you know it well, better than me. But what is the character of our neighborhood? Large, differently sized properties, very mature trees, open green space, God bless you, open green space between houses, lots that are not overtaken by structures, by hard surfaces. Patios, covered patios, and porches are hard surfaces, additionally to, as I understand them, additionally to structure. So the proposed floor space index, you know what that is, of 0.65, and the proposed lot coverage would be the highest in the immediate area, as well as in the greater neighborhood, would certainly set, I believe, an unfortunate precedent for future applications, in our opinion, and I think that would contravene the official plan affecting the character of this particular neighborhood. The proposed footprint and massing is larger than neighboring properties, an issue for us as we are in the backyard. Discussion so far has been the view from the front. Well, our view is significantly different from the back. With the package of information available on this file from, it was a planning justification letter from DPS Services. They quote the existence of a 1-story dwelling on the subject property. In fact, it's a story and a half. From the back, there are 2 distinct stories. So I asked myself, if I'm reading this letter and this basic description isn't correct, what else might not be correct in the documentation? Even Inspire Architectural Group in their cover letter referred to this as a single detached 1-story house with attached 2-car garage. Didn't anybody go to the backyard? Was there not a site view of the 2 stories that we see from our yard? So the first variance consideration, maximum lot coverage, proposes an increase of approximately, as was quoted earlier, 31.84 square meters. That's mostly coming from the back of the property. That's what faces us. Planning justification says it will have little or no impact. We respectfully disagree on that, and I would suggest that we will have further discussion with respect to trees on the impact of that further growth of the proposed property. Also, the properties quoted in the letter to support the lot coverage variance requested are using properties that don't have the same lot sizes. Of the 7 properties quoted, all but one of them are deeper properties by at least 36 feet. Most of them are 50 by 150, not the approximately 50 by 114 of the lot in question. Further, the drawings, as difficult as they are to read by the uninitiated, show that there is almost a 5-foot encroachment into the rear yard. This encroachment hasn't been mentioned in the planning letter. Also, on the initial application, it shows that the proposed building will go closer to the rear lot line by 6.22 meters. I don't think that's insignificant. 6.22 meters is almost 20 feet, more or less. And are there implications for water management, drainage? What will happen if they get that much closer? My second point is with respect to floor space index. You call it FSI. I submit to you that an increase of 20% in the FSI is no small variance. 0.20 is 20%. I think. I don't know if you do the math differently, but 0.20 is 20%. Further, please correct me if I'm wrong. In the opinion of the letter writer, one does not perceive an FSI value when looking at a dwelling from the street. I agree. When looking at it from the street, you don't notice it. The impact will be in the back.
I'm going to get you to wrap up if I can.
Pardon?
Just want to ask you to wrap up.
Oh, okay.
I'll let you go a little bit over because we weren't sure how much time we allotted Mr. Engelman, so.
Okay, I'm sorry. I didn't even realize that there was
It's okay.
an allotted time. So basically, the points are two, but the main point is the tree protection plan. There is the biggest tree in the whole community that is proposed to be torn down for construction-related purposes. And in this solution, normally in your plan, you take down one, you plant three, if it's construction-related, from what I understand. They're suggesting they will take down one, plant two instead of the three, because they don't have the space to plant three. So I would expect that, paying a fine of $585 or 83.
You're getting into minutia now, quite frankly.
Right, okay. So the tree canopy is an issue. It's the largest tree. It's going to be torn down
Understood.
because of construction. My final point is with respect to process. The neighbors beside were consulted and the neighbors across the street, but no consultation attempt to the two neighbors who are mostly affected, the ones behind. And I would suggest with a consultation and with more information, we might have actually not been here today.
Okay.
If we could have been part of the
Always
process.
a good idea to reach out.
Always
to
a good
the-
idea. We don't want to stop people from joining our neighborhood. We welcome people to come, but I would suggest that the reason that attracted them in the first place should not be then taken advantage of in changing it.
Okay, thank you.
Thanks for your time and
Thank you
for your consideration.
Actually, a good presentation.
Thank you.
Is there anyone else to speak on this item?
Yes, Mr. Chair, there's one more person, there's one person online. I just want to make sure, does any member have
any
a questions? I'll go ahead and unmute the resident who's online. Their name is Shira Braham. I'll go ahead and unmute them. Shira, you're unmuted. Go ahead.
Good afternoon. My name is Shira Brim. I'm Carmela's neighbor at 46 Warwood, so the property that abuts the applicant from behind. I don't really have anything to add after Carmela's presentation, other than just reiterating the fact that I didn't receive any consultation. Nobody came to my door or anything to, make any proposals or show me any drawings. And my concerns have to do mainly with just loss of privacy as it relates to how far back the new proposed structure would come. My daughter's bedroom would be kind of looking right into, their backyard, and I don't know how high up the new building is going to be and how far back it's going to be.
Okay,
Those are my only questions.
Okay, thank you. I just want to point out that we're not considering a rear yard setback variance. Where the house is going to be sited is as of right, so we can't really address that particular issue. But thank you for your presentation. Mr. Engelman?
Thank you.
Yes, through you, Mr. Chair, thank you for the opportunity. So, and I thank the neighbors for their comments. Regarding the trees, there is no proposed removal of any trees on site. There is, based on the arborist report we have provided, there is one injury proposed. One tree is proposed to be injured. That is the tree, the large tree in the front yard. And it's just being, if you zoom in there in the front, you can see there's a gray shading. That represents just a small extension of the existing driveway, and that encroaches into the TPZ of that large tree. That, to my understanding and based on the arborist report, is the only injury proposed, and there are no removals. So we are preserving all existing regulated trees on the site. And just regarding the neighbors, both who are to the rear of the subject property, again, as I mentioned in my initial presentation, we are exceeding the minimum required rear yard setback by 1.7 meters. So the house is actually set back larger than what is contemplated by the bylaw in terms of the setback to the rear lot line. In reference to the comment about me referencing this as a one-story dwelling, the zoning bylaw does not define a story as a partial story. Typically, when a dwelling has some living space in the roof line, I refer to it as a one-story dwelling, frankly, because I can't confirm whether there's living space in there or not. So that I just want to make that clear. There was no intention of not providing accurate information. Ultimately, this, again, planning staff tend to focus really on the numerical evaluation and the variances within the immediate context, which would be defined as properties on the same street within the same block and the block opposite. However, the official plan in policy 4.1.5 only states that you are to focus and place greater relevance on the immediate context when you are in instances of significant difference between the immediate and the adjacent and broader neighborhoods. In this case, in my opinion, there is no significant difference. Mostly the properties in the neighborhood are single detached dwellings, 1 to 2 stories in height, and therefore the immediate context should not be taken of greater relevance. The entire neighborhood, including the broader neighborhood, should be taken into consideration. And lastly, I'll just point out, I'm not saying that this situation, this property is the same as other properties on Meadowbank and Warwood. I'm simply saying that frontages and front yard setbacks are relatively consistent in the neighborhood. And those properties on Warwood and Meadowbank have similar frontages and similar front yard setbacks as compared to properties on Park Manor Drive and throughout the neighborhood. And so when you're looking at these dwellings from the street, you do not perceive the fact that these are larger lots with longer lot depths. So from a massing perspective, this dwelling will fit in with the neighborhood the same way that those existing dwellings on Warwood and Meadowbank fit in with the neighborhood. So those are my comments, Mr. Chair. I'm happy to answer any questions.
Thank you. Don't go away. I'm sure there's be some questions. Do any panel members have any questions for the applicant? No? No? Okay. Well, I'm going to ask some questions related to that. Are there any trees being removed that are as of right, within the as of right building envelope?
Through you, Mr. Chair, my understanding is that there are no bylaw regulated trees being removed. If you give me a moment, I can just confirm whether there are any trees at all being removed. But my understanding is that there are no bylaw regulated trees being removed.
And forestry is requesting condition 2, which means you're going to have to go through them anyway.
Exactly, and we are agreeable to that through you, Mr. Chair.
Okay. That's it. I mean, I only have a comment. I mean, if there's no questions, I'm going to, I guess, take this really into committee. And my only comment is that on the lot coverage, the examples that you've given are all less, with one exception, are all actually less than what you're proposing. And I think that's my issue is the lot coverage. I don't have an issue with the FSI. But anyway, I'll thank you, and we'll kick off some discussion, or if anyone's ready for a motion. So that's really my only comment. I believe planning is concerned about setting a precedent, given that there really aren't any other examples other than the one in that range.
Mr. Chair, I have a comment more than anything, unless I'm misreading it and someone can correct me, but planning does not propose an alternative in terms of certain conditions. It's a simple, straightforward.
Straight refusal, yeah, which actually surprised me because I thought they'd, you know, yeah, I guess we could have asked the applicant to see if planning was suggesting that there's a number they'd be happy with, but yeah. They were just not happy. Okay. Okay. That's kind of where we're at. I don't know if anyone else has any comments on that. And if not, if anyone's ready for a motion.
I'm ready to make a motion, if that's okay. Yeah, I share your concern, Mr. Chair, about the concern about coverage. I think it's kind of borderline. However, I don't think it's significant enough to not approve this application. In my mind, massing impact compatibility of a new house in a neighborhood is mostly dependent on height, width, as evidenced by side yard variances, front yard and rear yard adjustments. This proposal doesn't have any of those. It's built within the approved building envelope of the zoning bylaw. So I also note that particularly the north end of this cul-de-sac, there are some fairly recent rebuilds that look similar to what's being proposed here. So I think this is an area that's obviously in transition, and I think what's proposed here is in keeping with what this street's going to look like in 5, 10, 15 years. So I'm going to move approval subject to urban forestry condition 2.
Okay, Mr. Taylor's got a motion on the floor. Is anyone ready to second that? Anyone willing to second that? If not, I'm going to declare the motion failed. And if anyone else has another motion, I'd be willing to entertain that.
Well, I'm sitting on the fence on this one, and I'll tell you why I'm sitting.
I can understand that.
I think from where planning is coming from, it's where I'm looking at it too. The maximum coverage of 33 of the 7 examples that were provided in the, we'll call it the PJR, it comes to 37.57, and they're at 39. And then, as the agent indicated, that then also includes the porch and the rear deck. So that one I'm okay with. It's just the second one of FSI. Of the 6 examples provided, the average is 0.525, and they're looking for the 0.65, which is a significant increase, and that's where I'm tending to agree with city planning staff. This would be setting a new precedent.
Okay.
So,
do I hear a motion to refuse?
On that, I think I'm going to make a motion to refuse.
Okay. Is there a seconder to that motion?
With some fence sitting on my part as well, I will second that motion.
Okay. All in favor to refuse? Opposed? Okay, the application is refused. Thank you. Yeah, I think
I was going to ask Mr. Chair, would you like to do a break? We'll just call it 3:30 now and do a 15-minute. So at 3:45 we'll return.
Sounds good. Thank you.
All right, everybody, we're going to take a 15-minute recess. Actually, technically 17-minute recess. We will return at 3:45 with item number 2931 Fulham Drive A0083/24 EYK.
Not that I'm not worth it to look at, but I can tell you guys are trying to get the camera. Does that work? That works? Thank you. I'm not good at the handling, no on writing, so I go with the last one.
All right, everybody, welcome back. Thank you for hanging with us while we were in that recess. We'll be getting underway in a moment here with item number 29, 31 Fulham Drive.
Okay, welcome back, everyone. 31 Fulham Drive. This is an application for a new detached dwelling with an attached garage. There are 3 variances being requested. There were 3 that has been revised down to 2 now. And transportation is asking for 2 conditions of approval in the event that we should approve it.
Mr. Chair, both you and Natalia need to turn your cameras on, please and thank you.
That would be helpful. Well, my computer's timed out, sorry. Okay.
Stan, we've got Stan, there we go. Okay, thank you, everybody.
Okay, thanks. Sorry about that.
It's all right. The agent is virtual, and so I will unmute them now.
Yes, good afternoon, Mr. Chairman. My name is George Shama from Great Room Inc., the authorized agent representing the owner for this application. I believe the application is pretty straightforward. We are proposing a replacement single-family dwelling, and that is correct. We have eliminated one of the variances that we initially proposed. So we are now down to the two variances, one being driveway width and the other being the FSI. If there are any questions from the committee, I'd be happy to answer them.
Nope, I think we're good. Thank you. Anyone ready?
Yeah, if there are no questions, no, then I'd like to move a motion. I believe this application meets the 4 tests. It's very straightforward, subject to the transportation conditions.
Second.
Thank you. All in favor? Unanimous approval. Thank you for waiting for us on that one. Okay, item 30, A, B, and C is 111 Evans Avenue. This is an application for consent to sever the lot into 2 undersized residential lots. There is, transportation is requesting conditions of approval. Engineering and construction services have conditions of approval and comments, or advisory comments. We have a letter of concern from 382 Melrose Street, and I could not find a planning report on this. I don't know. No. Okay.
For your notes, Mr. Chair, the area resident at 382 is present on the call.
Okay. And forestry was requesting deferral, or in the alternative conditions 2 and 1. So, okay, and Mr. Price is at the microphone. Welcome.
Good afternoon again, Mr. Chair, fellow committee members. I'll state my name for the record. Addison Milne Price, planner at Design Plan Services, Inc., located at 900 The East Mall, Suite 300, here on behalf of the owner.
Okay, I think we're going to need a full presentation on this one.
Absolutely, I'm more than happy to go through this for you. The applications before you propose to create 1 new lot by severing an existing residential lot for a total of 2 lots and constructing 2 new single detached dwellings on each lot. There are 2 minor variance applications that are associated with the consent to sever application, each with 10 identical variances. Note that through our consultation with planning staff, we did revise the height of each proposed dwelling from the original 9.5 meters to 8.34 meters. The buildings were initially proposed with a front facade that measured to 9.5 meters, and the removal of this feature has led to that reduction in height without any change to the proposed variance or any other massing of the building involved. I also want to point out that planning staff, as well as engineering and transportation, have provided no objections to this application. With respect to urban forestry's recommendation to defer this application, I can point out that the arborist report that we provided does state that the city-owned tree is only being requested to injure. It is not being requested to remove that city-owned tree. Although there are removals requested for the private-owned tree in the rear of the property, should the committee see fit to approve this application, we have no issue with dealing with urban forestry and finding a solution that works for them through that condition process. I also want to address the letter of concern from the adjacent property to the rear, 382 Melrose Street. This neighbor wrote in their letter that they oppose the removal of the rear cedar hedge along the shared property line, and I've confirmed that the owners have no issue with retaining this cedar hedge. And before I get to the variances in just a bit more detail, I want to point out that this application does have a road widening conveyance associated with it. and several of the variances are related to this conveyance. Now, variances 1 and 2 both pertain to the lot frontage and lot area respectively. I did provide a cover letter that provides justification on the severance itself, so I won't go into too much depth, but I will just point out that the most common lot frontage in this neighborhood is 7.62 meters, which is practically indistinguishable from the 7.6 meters that is proposed through this application. And there's a similar situation with the lot area. The most common lot area in this neighborhood is 278, which is also quite similar to the proposed 263 area proposed, especially when you consider the right-of-way conveyance. Now, variance 3 pertains to the proposed FSI. We're proposing an FSI of 0.78 for each building, and this FSI will present a massing that's in keeping with the existing character along Evans Ave and along with the broader neighborhood as well. There are several FSI decisions within the neighborhood that attest to this fact, including 115 A and B Evans Ave approved at 0.77 FSI, 101 Evans Ave approved at 0.71 FSI, as well as 298 Melrose Street approved at 1.03 FSI, and 320 Melrose Street approved at 0.78 FSI. I'll point out as well that several of these comparable buildings have not yet had the road widening taken, and when this road widening does get taken, the lot area will shrink and therefore the resulting FSIs will increase. However, the massing that we're proposing will be quite similar to what currently, to what we're proposing and what exists along Evans Ave. Now, just in reference to the time I have left, I'll speak to variances 4 and 9 together because they both pertain to the front yard setback. And it really is a result of the road conveyance requirement. You'll note that on the plans provided, the proposed dwellings are in line with the front walls of both adjacent dwellings. However, since both adjacent dwellings have not yet had the road widening taken yet, the front yard setbacks are technically smaller and therefore trigger a variance. And this also applies to variance 9 as the front porch now encroaches into the required front yard setback, but in a similar manner, the proposed front yard porches will align with what is along Evans Ave right now. Now I'll speak to variance 5 and 8 together as they both pertain to the side yard setbacks. Variance 8 specifically pertains to the side yard setback of the rear deck, which matches the setback of the building. The proposed side yard setbacks are both internal to the proposed development, and by this I mean that the setbacks of both adjacent lots to 111 Aves, namely 113 and 109, will be compliant with the 1.2 required side yard setback. And I'll also point out that the 1.2 meter setback, it's based on the required minimum frontage, not the resulting 7.6 meter frontage, which would typically correspond to 0.9 meters as per the bylaw. Now, variance 6 pertains to building length. With regard to this variance, I'll just point out that the proposed building lengths do not extend past the rear main wall of the adjacent building at 113 Evans Ave, and as such, this variance will ensure a smooth and consistent line of rear main walls in this neighborhood. Variance 7 pertains to the front and rear exterior main wall heights. Firstly, the proposed dwelling is compliant with the overall height of 9.5, and this proposed variance is only relevant to the height of the exterior main walls. This main wall height will be consistent with previous main wall heights that have been approved in the neighborhood, including 39 Evans Ave at 8 meters, 80 Evans Ave at 8.25 meters, and 101 Evans Ave at 8.33 meters.
Can we get you to wrap up?
Absolutely. I'll just lastly state that variance 10 only pertains to the front porch canopy. It does not overhang further than the eaves. This concludes my presentation, but I'm happy to take any questions.
Thank you. I believe we have someone else to speak on this, area resident. I don't think so.
Hello, thank you. Good afternoon. My name is Ramiro. I'm the owner of the property towards the rear of this lot. So thank you, Chair and Committee.
Welcome.
I just wanted to, reiterate what was said Thank you, thank you. Just to reiterate what was said, and I appreciate the comments made regarding the cedar hedge. These cedars were planted on the lot line. I was actually in committee of adjustment just last year for our renovation that we did, so we had our survey done, and it was confirmed that the cedar hedge row is what's dividing the two properties. And I understand there is a couple of other trees, and God bless. I want them to build and do what they got to do. We did ours, and we were thankful that we didn't have any issues with our neighbors either. I know there is a chestnut tree that is dead. It's a pretty big one, and it probably should come down. But my only concern is regarding that cedar hedgerow and just getting some kind of confirmation that it won't be damaged or removed.
Okay, I think he's already indicated that it's going to remain, but I'll get him to reiterate that in a minute. Is there anything else, or do you have any concerns about the application itself?
No, I'm glad to hear that they've reduced the height, because I also have daughters, and so our house obviously looks into that. We'll be looking at those properties, but no, we have window covering, so we should be okay. And yeah, like I said, Godspeed. As long as they're within their rights, then they should be able to do that. My only concern is that because it's providing privacy, obviously, and it's also what's dividing the two lots. So that's
Okay.
my only concern.
All right, thank you. Mr. Engelman,
Thank you.
thanks. Do you want to just say it again?
Absolutely. Thank you to the member of the public for their submission. Yeah, the owner has no issue with the committee imposing some sort of condition that requires the maintenance of the cedar hedge. I'm not sure on the legalities of such a condition, but they are aware of your concern, and they absolutely have no intention of removing that cedar hedge.
Okay. Yeah, I mean, maybe they can reach out and you can do a letter agreement or something. I'm not sure if we want to do a, yeah. Okay, thank you, Mr. Price. No questions? No. In committee then, for discussion, or anyone ready for a motion?
Yeah, so if there are no questions, I'd like to move a motion to approve it. I believe the application meets the 4 tests, subject to the conditions in the ECS and forestry memos. Am I missing any? And transportation.
We've got transportation and, no.
That's it?
It's ECS, transportation,
That's all in ECS, right?
and forestry.
Yep, I said forestry.
Yep.
Yep.
Seconded, all in favor? Okay, unanimous approval. Thank you, Mr. Price. Our next item, number 31, and now we get into the deferred items. So this is 11 Sunnydale Drive. This is an application for a second-story addition over an existing dwelling and a 2-story rear addition and east side addition. This item was deferred from February 8th. We have 5 variances being requested. The forestry is requesting condition 2. Transportation has 2 conditions of approval. And we have a number of form letters of objection, and we have a few form letters of support. 31.
Mr. Chair, just before we dive into this, I want to bring to your attention that the area residents are present in the chambers and there is a few online. If I could, though, I have one person who is present online who may not speak. I'd like to confirm with them right now if they do plan to speak or not.
Sure.
Thank you.
Go ahead.
And this also, I can get a microphone check
Yeah,
too this
give
way.
me a chance to get set up here too.
Julie Ann Doherty, microphone check. Are you there? Hello? Julie Ann?
Hi, can you hear me?
I can. Perfect. Are you interested in speaking or no?
Yes, I'm
You will
available
be.
for the
Perfect. Okay, so what we're going to do is we'll do the folks that are in chambers first, and we'll work our way down. You're the third on my list of people that are virtual to speak. So thank you then for confirming.
Awesome. Thank you.
Awesome. Thank you, Mr.
Okay,
Chair.
thank you. Mr. Marzinski?
Yes, good afternoon, Chair,
Good afternoon.
Mr. Chair, and committee members. If I could just, jump to a presentation. Thank you, Adam. To state my name for the record, Chair, through Martin Mazurski, that's Mazierski, 88 Scott Street, Toronto, here on behalf of the applicant and the homeowner of 11 Sunnydale Drive. Now, if I could please just jump to that presentation first. I wanted to kind of explain what this first page of the presentation addresses, and I understand that the panel has seen this presentation. This slide explains the evolution of the proposal, how the massing has changed from the original Committee of Adjustment decision that refused the proposal to the initial Committee of Adjustment application this time to the now revised Committee of Adjustment application. And just to explain for context, when we're looking at some of these plans, on the left hand, which is the west side, is the property at 13 Sunnydale Drive. You might want that for context because there were some comments from them. And on the right side, on the east side, is the property at 9 Sunnydale Drive for context. And again, if you see at the bottom and right, that's the southeast side, you see the massing for the addition at the back. Whereas the different grid at the top is the existing footprint of the one-story building. Now, I wanted to kind of set the stage just for the rest of my presentation. And each site plan on this site shows the existing site setback of the property at the front. So if you see those site setbacks at the front, they wouldn't be compliant with the current bylaw, but they're the existing setbacks. And a lot of the setback provisions for this property are based on those. Now, if we go to the first set of plans at the very top, Adam, if you don't mind. No, still the first slide top. If you could just zoom in on that a little bit. So that first set of plans, represents the proposal that was refused at the Committee of Adjustment on June 22nd. Of 2023. There's an FSI of 0.82 and a lot coverage of 41.2 at that time. If you see at the rear width, the left side followed the setback of the existing front of the property, and now it's 1.19 meters. And on the right side, basically you have a setback that's set back a little bit further than the existing right side setback of 0.43 to about 0.90 on that side. Those would have both complied at the time of the zoning bylaw because their extension is backwards. So all the variances there was variances that are still here now for side setback, they apply to the addition on top of the existing envelope. Those setbacks at the time actually complied because their extension is backwards under the current bylaw. Now, the rear addition at the back, you also see at the time, the rear addition resulted in a total length of 14.4 meters. And the length of that addition was 3.08 meters at that time. Now, if we jump to the second set of plans, those are labeled as the second set of plans. At this point in time, this was the original Committee of Adjustment application we revised. FSI here dropped to 0.79, coverage to 39.5. At the time, the left side was stepped back, still at the same place, followed the left front wall. And the right side had actually been stepped back a little bit further to a setback of 1.2 meters. 1.2 meters is the required setback of what this would have been required if this was a new build along that side. That was to give a little bit more space to the neighbor on the right already at that time. Now, the last set of plans, and again, the length from that building at this point in time is an extra 2.65 meters addition for a total length of 13.97 meters at that time. Now, the last set of plans this is the most recent set of plans. These were filed with the Committee of Adjustment as the current set of plans. After discussions with the neighbors, the left side has now been set back an extra 0.64 meters beyond the side setback of the existing footprint on the left, which is the west side. In addition to providing more separation from the neighbor on the left side, this keeps the proposed excavation further away from a mature tree in the rear yard. As per the attached filed arborist report, that tree, the mature tree in the back, will now be protected thanks to this. Plus, to add to that, if you look at the actual plans that are on record for this, on top of the setback being increased, that green area there, part of the deck was converted into a planter to push the deck further away from that neighbor. Again, that was done in response to the neighbor's concerns. And you see on the right side of the plans, we kept pretty much the same setback, but the deck on the right-hand side was actually narrowed down. So if you see the deck on the right-hand side is eliminated to push it further away from that neighbor that was concerned about it. So now the deck is very narrow, just in the middle of the property. Now, to address this to the requirement of the required setback, I kind of explained what the required setbacks are. I wanted to explain the depth of the building versus the required depth. This building is permitted, and I know because there's going to be concerns from the neighbors about the length of the addition. The building length is currently at 13.15 meters, is 3.85 meters less than the 70 meters permitted by the bylaw. The rear yard setback of the actual building is 8.75 meters, which is 1.25 meters greater than the required setback under the zoning bylaw. So the building is further away from the rear lot line than required by the zoning bylaw by 1.25 meters, despite the FSI and GFA variances, because the building is situated very much towards the front of the lot. And panel, you've seen the rest of my presentation on slide 2. I just like to quickly explain that there's comps. The building footprint have been stepped back from both sides. The floor area contains the 2-story massing, does not trigger any height-related variances.
And if you could wrap up right after that.
Very quickly, Chair. And so I'll jump. Last thing about the eaves. The roof eaves are in existing condition on the first story. Now the second story has been added, but the roof eaves are the same distance from the neighbor as the original roof eaves. The driveway is in existing condition, Chair. And if you look at the last set of slides, the slide 3, there's comparables there on Sunnydale Drive. There's comparables, all the comparables for FSI that I identified. And there's comparables for selected properties 3 blocks directly north and 3 blocks directly south. You'll notice just the FSI numbers, but the actual GFA numbers there show that there's quite a few GFA numbers that are actually higher than the proposal. The proposal's GFA at the top is 259.75.
Okay, I'm going to ask you to wrap up.
Thank you, Chair. Last comment, sir, no objections from planning, no objections from forestry, and no healthy trees being removed as part of this proposal. Thank you, Chair, for the little bit of additional time.
No worries.
A big presentation.
There was a mouthful there for sure.
Yeah.
Okay, thanks. Any questions from panel members? No? Okay, thanks. We'll come back in a few minutes. Okay, so in order, I guess, Pamela Mancini, is that? Good afternoon.
Good afternoon, Mr. Chairman and committee members. My name is Pamela Mancini, and I'm here representing both my husband and my concerns regarding the proposed dwelling on Sunnydale Drive. I'm here also to represent my daughter and her partner's concerns. My husband and I live on the same block and close to 11 Sunnydale Drive, and my daughter, Shauna White, and her partner live directly behind the property. I'm here representing my daughter because she works as a nurse, and although she registered to be present, it wasn't certain that she would be able to participate. So I'm hoping that I'm able to go over the 5-minute limit by 1 or 2 minutes, as I'm representing both households.
I'm hoping you're going to stick to your 5 minutes because we have a number of speakers, and I'm hoping they're not all going to be saying the same thing. So
sure, I'll try to be as brief as possible.
Thank you.
Our concerns regarding the proposed dwelling relate to the requested variances concerning floor coverage and floor space index. Although we recognize that the applicants have made some modifications to these, we still have objections to them. Their approval would mean that the dwelling would be the largest one on the block of Sunnydale Drive, where the lot lengths are relatively short, being only 93 feet long. Approval of the variances relating to floor coverage and FSI would also mean that the whole house, both the main floor and second floor, would be extended lengthwise to the back by 6 feet 2 inches. It would be the only house that would not be aligned with the other houses on that block. While there is one house on that block at 19 Sunnydale Drive that has a small extension on the main floor, it does not occupy the entire width of the house and does not include the second floor. The considerable increase in house length of the proposed dwelling would negatively impact us. The increased house length, together with some other features of the construction design, would markedly push the house backwards towards us. The walkout deck, which would be 3 feet 3 inches above ground, without taking into consideration the height of the railings, the raised planter, which we were told would be the same height as the deck, the walkout deck, and a staircase going to the basement door would occupy the entire width of the house and extend outwards by another 9.7 feet. The combination of the increased house length and these features would extend the house backwards by a total of 16 feet. Considering the fact that the lot lengths of Reed Manor are also relatively short, only 93 feet long, the effects of having the house pushed back towards us and in our face would be even more pronounced. It would severely restrict our privacy, our view of open space, and our ability to just enjoy our backyard space without visual and noise interferences. We believe it is also important to point out that the rear yard setback is absent in the application. As the rear of the house has a walkout from the basement, we believe a major portion of the rear terrace area would be excavated to accommodate a walkout. Therefore, it is possible that the measurement for the rear yard setback should be taken from the deck and not the house. This would necessitate a variance application. To conclude, we object to the requested variances for floor coverage and FSI, as in our view, they are not minor but major. While there are some larger homes on the north side of Sunnydale Drive, they do not stand out as much in being disproportionate or oversized as they have larger lot sizes. Also, we object to the requested variances as their approval would threaten to set a precedence for future housing projects on the block. Given that both the south side of Sunnydale and the north side of Reed Manor have some of the most shallow lots in the entire neighborhood, extending the houses lengthwise on both streets by such a large degree would severely reduce the yard spaces. As there are still many small homes in the back-to-back block of Sunnydale and Reed Manor, approval of the requested variances for greater floor space and FSI would markedly diminish the quality of the residents' backyard environments, reducing their privacy, natural light, and views. The bylaws should protect us from these types of excessive requests that would adversely affect us. We are not opposed to development, but it is our hope that a balance could be reached between growth and the preservation of our existing community. In its present form, the application for the proposed dwelling would reduce the overall integrity and character of the community. In our view, the application is a total obliteration of the performance standards for the zoning bylaws. Thank you.
Thank you. Don't go away, just in case we have questions.
Sure.
So my first question is, you're questioning whether there should in fact be a rear yard setback variance, is that correct?
Yes, that's correct. I'm not very knowledgeable about that, but from my own reading, and it seemed confusing to me, but I could not determine where it would be, and it's not indicated on the plan. And because there is excavate, they're going back.
Okay, I got it. So just on the plan, there's rear yard setback is measured from the main wall, correct? Not from the deck. Depends on the situation. Okay, that's fine. I'll come back with the.
Yeah, my question was because of the construction to put the platform to have the stairs. There would be excavation.
Okay.
But I'm not certain.
We'll come back to that one. That was the only thing I wanted to clarify from your presentation. Does anyone else have any? No. Okay, thank you.
Thank you.
Wendy Robertson or Frank?
Mr. Chair, it will be Wendy who will be speaking. I will unmute them now. Wendy, you're unmuted. Go ahead.
Is there anyone else in the room before we go to? No. Okay.
No, Mr. Chair.
Okay, thank you.
Sorry,
Can
Wendy.
you hear me?
We can.
We can.
That's okay. Okay, great. Hi, my name is Wendy Robertson. My husband is Frank Mioto. We live at 13 Sunnydale, directly to the west of this proposal or plan. We've lived in the neighborhood for 24 years and enjoy our small field community in the big city. Anyways, we're not opposed to development. We have a lot of small houses on our street that do, it needs to be rejuvenated for sure. My concern is the lot coverage. From looking and reading on the city websites, it means a portion of the lot that is covered by any part of any building or structure on or above the surface of the lot. So I'm just wondering why that in this case does not include the decks and the porches. We just heard from 7 Park Manor, and their lot coverage was including the rear patio and the front porch, and it was denied at 30% coverage. 11 does not have the deck or the porch in their lot coverage. They are at 38.1%, so including the porch and the deck, they would be well over 40%, roughly about 42.9%.
The one, but just as a point of clarification, the one that was denied was just under 40. It was not at 33, which would be, you mentioned.
No, I understand that. I understand that, but it was at 39, and these now
Correct.
are at 40. If we take into account the front porch, which is not a small front porch, it's 101.7 square feet.
Okay, no, good point. We'll come back to that. Please continue.
The back deck is also large and not included, and as Pam was saying, the basement stairs go out further than less than 0.578, but I don't know where those regulations on concrete stairs coming out of a walkout basement fall in lot coverage. So I just find that when we look outside, you know, there's also a focus on, does it fit in the neighborhood? When we go outside in our backyard, everybody is at the same back, except for that one house that Pam was mentioning that just has like a little alcove coming out of their kitchen. Also they're now bumping out at the front as well. So it will be out the back and out the front with the porch and the addition of 6 feet on the back of the house, not including the deck. So it is going back further back, further front than all the neighbors. There was a mathematical, if you look at the plans, like we had a lot of neighbors come to us very concerned because on the notice, it has that they are 38.1 on their plans, lot coverage. On their plans, it says 37.5. I understand there was a clerical error, but there's been no work to get that cleared up. So we are just working on the plans that have been posted by the city. And if they're incorrect, then we should have been notified they were incorrect. So then, yeah, we don't, sorry, I'm not as eloquent as Pam. You know, I don't believe it is a minor variance because it needs to be minor in both size and impact. And this will dramatically reduce our privacy. It's going back 6 feet. It has side windows. I have a special needs daughter. We spend all our time in the backyard, and they're going to be right there. And it is not an appropriate change. It is not an appropriate development into this neighborhood. As Pam said, we only have lots that are 93 feet deep. The north side of our street, they're 127, I believe. It is just simply too large of a house or a build in the size of lots that we have. I understand everybody wants bigger and better. Well, then you need to work in the lot size you bought. And if you wanted the larger build, then this is not the lot size that will accommodate it. So we are against the lot coverage.
Thank you. Are you good?
Yeah.
Okay, thanks very much. Any questions from panel members? No, thank you. The next speaker, is there a speaker or are they just on to here?
No, next speaker, it would be Susan White.
Oh, okay, I don't have that. Oh, yes, okay.
Oh, sorry, Shauna White.
No, I was representing her, so she's my daughter who lives directly behind.
Understood. So Shauna, I had her on my list of participants, but I do see she is no longer available to speak. Though she is on the call, Mr. Chair, but I guess they do not have the.
Well, if she wants to speak, I suppose she can.
Well, I see that they haven't authorized to use their microphone, okay. So.
And then Julianne Doherty.
They are present. They do want to speak, so I will unmute Julianne then. Julianne, go ahead.
Hi. Yes.
Good afternoon.
Hi. Can everyone hear me?
Yep.
Good afternoon. Okay. I will try not to repeat anything. The reality is the lots are very small, as Wendy stated. They have 1.5 feet, 1 foot 5 inches from my side from the east side, which is where I'm at. So regardless of anything, I will be subject to having to have some encroachment or consistent interactions with them because of the proximity of the lots. The lots are much smaller. Part of the concerns that were addressed is also around the measurements. It's really confusing. There's a set of different numbers that are going around, and I want to make sure that if I'm opposing to the right set of numbers. I do acknowledge that they have significantly reduced it from their initial proposal, which was straight out recommendation to reject from the city. However, it is still a very, very big house for the size of the lot. Our lots are much smaller. They have.
Sorry, you're kind of fading in and out.
Sorry, can you hear me now?
Yep.
Can you hear me better? Okay. They have very little space between the houses. And there's also concern of how they're going to build the house. They have stated that originally, I think it was in the 50s, that the percent of the lot that was going to remain, now it's at 50.9%. Anything above that triggers a major variance. I don't trust the numbers that were provided. Plus, how are they going to get to the backyard to dig out, to build the weeping tile, to put in the sump pump, to put in the drain for the sump pump? Those are all things on a very small lot that have a huge impact. Yep.
Sorry, we're losing you again, but we don't get into the how-to. That's between buildings.
I realize that. I realize that, but those are part of the reasons why having a very small lot means that going above the standard and pushing the boundaries is concerning. But I'm gonna defer to what the committee says. But I do have questions around the numbers that were provided, as the math just doesn't add up. And you guys have seen all the letters. Hopefully you've read them. We have concerns.
Okay.
Thank you.
Thank you. We'll get the applicant back to address the numbers. Is there anyone else to speak to this?
No, Mr. Chair, that will be it.
Okay. So if we can get Mr. Majinski back, please.
Thank you, Chair. Panel members, so I appreciate the opportunity to respond to some of those concerns, and I wanted to go through them kind of as general big picture response to some of the issues raised, and then maybe detail one by some of those concerns. The general concerns about the variances haven't been identified, and that was related to the FSI and some of the letters. I believe Ms. Robertson raised some issues about the lot coverage, and other neighbors raised issues about lot coverage relating to the rear platform and the front porch. I can say that as soon as I took over this file, the first thing I did, I told the owners, because the prior application didn't do this, is I told the owners to get a zoning notice done by a zoning examiner. And this final set of plans was evaluated by a zoning examiner. So the applicant took it upon themselves to get all of the variances verified by the zoning examiner. So the lot coverage, all those measurements, the FSI, those are not from site statistics on the architect's numbers. They go to a zoning examiner, so the examiner can do those numbers and can provide it to the committee in the form of a zoning notice. I know that there's some comment about the lot coverage number on the site statistics not matching the actual request in front of the committee. What I'll say is I've looked at a lot of these applications by the time we get to an appeal, and I know that most times probably the exact lot coverage numbers on the site statistics by the architect won't match the examiner precisely, because those are fine little calculations done by the examiner, and the percentage points never round out exactly, or rarely do. And I can say that that's the whole point of getting a zoning notice. So those things can be verified by a zoning examiner, and the proposal that's put in front of the panel addresses what the examiner has identified based on the plans, not perhaps some math done on those drawings. I can come back to specific detail on the FSI just to explain that one. So before I jump into specific, in general, the zoning notice has confirmed the variances and has identified what the numbers are and what the variances are not there. If some variances appear on these plans and on a later building permit application, the examiner flags them, they won't be approved just because this proposal is approved today. If an examiner missed something, and again, the examiner's job is not to miss something. If the proposal misses variances and it's caught at the building permit stage, I will have to come back here in front of the committee and we'll have to explain those other variances. But I understand I did all I could to verify them, as have the applicants. Again, I empathize with the neighbors being concerned, because sometimes neighbors are very careful in reviewing every little number, but sometimes things don't match exactly. And on the FSI issue specifically, if I can comment on it, the plans were revised so many times, often to appease some of the neighbors, especially on the flanking sides. When the architect updates the plans, they do a calculation on a spreadsheet of what are the new lot coverages and the new FSI on my numbers. And then they take those numbers done on a separate spreadsheet and they translate them to the actual plans. The architect on the latest revision, which we're trying to get into quickly to get a new zoning notice, did the update of the plans, did the numbers, updated the total FSI number, but forgot to update all the calculations that get them to there. There's a number on there, more specifically, there's a number of 37.62 that shows up as the proposed first story addition. That number is not 3672, it is actually 29.77. The architect did not have time to adjust it. That's a difference of 7 meters squared. That 7 meters squared accounts for the exact difference in FSI that's actually being requested at 0.75, and the number that some of the neighbors, one of the neighbors jumped at and said, well, this number should be 77. Again, the variances in front of the panel today are not based on the site statistics on that plan. They're based on an examiner looking at the plans and doing their own math. The architect's math actually matched up with the planner in this case, the examiner, but all her calculations weren't updated, so that's why it caused the confusion of neighbors. I empathize with the neighbors. I understand they're not familiar with the process, but the applicant has done everything to confirm those variances. As to some of the specific concerns raised by Mrs. Mancini, again, I understand her concerns, but I try to preempt some of them about the building being closer to the back. The addition at the back is now reduced to basically 6 feet. And the one thing, I think I didn't explain it in the plans, but I had the plans up. Despite this, some neighbors have raised the fact that it's a smaller lot, and it's some of the objections. If you look at the plans, the building is very much pushed to the front of the lot. All the buildings on this side of the street are. You see where the lot is, it's pushed fairly far to the front of the lot. That is why, despite this FSI lot coverage number being what they are, we still have a rear setback of 8.75 meters, rather than the 7.5 meters in the bylaw. Again, those are set back, I believe, pretty close to the front lot line. So that's why we can maintain that proper rear yard setback. And again, the building is almost 4 meters shorter than permitted by the bylaw in general. And Ms. Mancini also had concerns about the massing at the back. I'm not sure how much is privacy or massing, but I'll explain. The massing at the back is also narrower than the building is allowed to be. Ms. Robertson's concerns, again, lot coverage, examiner confirmed the lot coverage. The stair walkout is not part of lot coverage. Again, that was confirmed by the examiner. If there's a mistake, I will have to come back here. The front pump out at the front, the examiner look at the porch. The porch does not trigger any variances. I addressed the lot coverage on the plans. The side window, if we can go to the plans, if the panel wanted to scroll through the actual drawings, the floor plans of the building, you'll see that none of the side windows on the left side of the plans, that is Ms. Robertson's side, are actually...
I don't think anyone raised issue with side.
I think Mr. Robertson said something about windows on the side of the
I'm
building.
going to get you to wrap up, and we will have more questions, which I think you can answer some of the stuff on.
Sure. And again, I think that walls to remain, again, that was the math, the drawings showed the amount of walls to remain. The examiner looked at that, and the examiner determined that it was an addition and set up a zoning notice based on an addition. The numbers would look different if more than 50% of the walls weren't kept in place. The variances would be different. Whatever variances I get approved today wouldn't work for me on a building permit, and I'd have to, again, come back here. But again, that was evaluated by an examiner because I wanted a zoning notice, because I wanted assurance for my client, for the panel, and for the neighbors. So thank you, Chair. I appreciate that.
I'm going to get you to address the rear setback question, and I understand why the deck would not be included, but in the basement walkout, if it's below grade, should that not be included?
No, because the basement walkout is not an enclosed space, so it's not treated as
it's not enclosed. Wall. It's going to be open.
Yeah, so it's not treated as a remain wall. If what happens is sometimes what people do is they have an excavated area of kind of like they built a basement below their deck. That's when that triggers it. I've seen it because I have to argue this many times at appeals. how it doesn't, because it triggers a bunch of laneway variances and garden speed variances, but that's
Okay.
another topic.
So, yeah, I mean, technically, you're in compliance, but I think their argument is that the built form is close to the setback.
I agree, but again, the zoning bylaw, which regulates the privacy and the separation for the neighbors, and it determines what's acceptable to the neighbors or not, sets 8.75. We're at 7.5. There's separate provisions for the deck about encroachment into setbacks.
No, understood,
And also,
understood, yeah.
Chair, I'll add one more point about the privacy issue. There's also separate provisions for a deck if it's higher than a certain distance off the ground in the back.
Yep.
If the deck was more than 1.2 meters, there'd be other provisions about the depth and all of that. And none of that was triggered because the deck is low enough. And the deck is low enough, so it doesn't trigger those privacy concerns.
Understood.
Thank
Okay,
you, Chair.
thank
I
you.
appreciate the extra time.
Okay. Any other questions? No? No? Okay, thank you.
Thank you, Chair. And panel.
Okay, so there we have it. And we have no revised report from planning, so we can only assume that they are now okay. We have 2 conditions from transportation and 1 from forestry. Anyone have any comments?
No comments. I'd like to move a motion then. I think the application does meet the 4 tests. I understand the concerns of the residents, but as the agent indicated, a lot of the concerns raised didn't trigger a variance. And with that, I move a motion to approve the application subject to the forestry and transportation conditions.
Okay, we have a motion on the floor. Is there a seconder?
I'll second, Mr. Chair.
Okay, Mr. Taylor, all in favor? Okay, we have unanimous approval. Thank you. Our next application, number 32, which is number 19 ATHLONE Drive. And this is an application for a new detached dwelling with an attached garage. There are 3 variances being requested. This is also a deferred item from February the 8th. Forestry is requesting denial or in the alternative conditions 2 and 1. Antonatella Wild is the agent, and is she online?
Yes, hi.
Hi, good afternoon.
So I'm Antonella Wild, the agent and the designer of the home. As you see, we revised the variances, removed a couple and reduced a few from the last meeting.
I think there's been some substantial changes made for sure.
Substantial, and they also met with all their neighbors, just set up a day to meet with everyone that had concerns. And I don't believe that there are any more concerns unless someone is present to speak. Everyone was satisfied with the revisions. I'm concerned with Urban Forestry's request for refusal because we're not requesting any variances for front yard setback, garage width, or landscaping of the front yard. So anything that would impact that tree is as of right. The coverage, you could argue, is at the back and as well as a GFA with a partial 3rd floor actually reduces the footprint of the home as well. I'd be happy to answer any questions or speak to the variances I believe are minor. I could speak to them individually, but if you'd like any more information, I'd be happy to answer.
I think we're good. I'll see if there's any questions, but as we've both mentioned, there's been substantial revisions since the original application, and you're down to 3 variances, and I don't believe there's anyone objecting. And forestry, I think, in the alternative will accept conditions 1 and 2. I'm assuming you're not opposed to those conditions.
No, we're not.
Okay. Any questions? No. Okay. Anyone ready for a motion?
Sure. I think the application is fairly straightforward. I think it does support the 4 tests and would make a motion to approve subject to the forestry condition.
Okay, thank you. Mr. Dalton, is there a seconder?
Second, Mr. Chair.
Thank you, Mr. Taylor. All in favor? Okay, unanimous approval. Thank you, Ms. Wild. Okay, item 33. This is number 4. I don't know if it's pronounced DALEGROVE or DALEGROVE CRESCENT. And this is an application to construct a detached dwelling with an attached garage. There are 4 variances being requested. Forestry is requesting condition 2 in the event of approval. And we have, already, thank you. Welcome.
Good afternoon, Mr. Chair and fellow committee members. My name is Oriana Nanoa, planner at Design Plan Services, Inc., 900 the East Mall, Suite 300, Toronto.
Okay, I don't think we need a full presentation. In fact, I'm not sure we need a presentation at all. Does anyone have any questions?
No, and if no one has any questions, this is a very straightforward application. I believe it meets the 4 tests. So I'm prepared to make a motion. No
Please.
questions, no comments.
There is a forestry condition.
Yes. I haven't made the motion yet.
Okay.
I'm making the motion to accept the application as presented with the condition of urban forestry.
Okay, seconder?
I'll second, Mr. Chair.
Okay, Ms. Povic, all in favor? Okay, unanimous approval, thank you.
Thank you.
Okay, item 34 is 26 Edgecroft Road, and this is an application to construct a new detached dwelling with an attached garage, and there are 9 variances being requested. Excuse me, which is a reduction of 1 from the February 8th deferral. And Mr. Pankowski, back on the line. Jonathan, are you there?
I'm here, Mr. Chair. Good evening.
Good afternoon. Hoping not to get into the evening tonight.
Well, this is it for me, so.
Okay.
Making good progress.
We're getting there. We're getting there. Okay, maybe just a brief overview on this one.
Yeah. So this was actually deferred, not for any reasons of any department having an issue. It actually just had to do with an internal calculation of the actual garage itself. There's a reason for that deferral. Now, basically, you just have a application for a new dwelling. Yes, there are 9 variances, but if we look at the kind of the 9 variances, they largely are ticky-tack, in my opinion, where we're requesting, an increase of 1.5% in coverage. Again, a modest increase in the building length from 17 to 17.58 meters. The rest are really architectural features, a parapet, as well as the width of the stairs. In terms of the height, this is a true flat roof house. We don't see a lot of those these days because it's tough to fit that 7.2 meters into a reasonable dwelling. But in this case, it really is a conventional 1-story above the garage, leading to just a 7.45 meter high house, which also then would be essentially where the main wall height would be. Again, there are 9 variances, but I would really say they kind of are ticky-tack in what they lead to.
Okay, yeah, a lot of them don't look to be that onerous, yeah. Okay, any questions? Nope. Anyone ready to do something with this one? Ms. Popovic?
Yeah.
Thank you. I agree that on balance, this is a relatively straightforward matter. I agree that the variances are subtle and that it meets the 4 tests. I'm just looking to see, I do not see, just a minute.
No conditions.
I don't believe there are any
And
conditions
I have no other
requested
reports other than transportation.
No.
I move to approve.
with no conditions.
I don't see any conditions,
Yep.
agreed.
I'll second that motion.
All in favor? Okay, unanimous approval. Thank you. Thank you, Jonathan. Okay, our last item, 171 John Street, an application for a new detached dwelling with an attached garage. There is one variance being requested, and it is for FSI, which is, again, a substantial change from the original application back in February, which I believe had 6 variances. Who's the speaker?
Mr. Chair, while you look, the speaker is Paul Dacuna. I want to bring to your attention, there was an area neighbor on the line earlier, but they have since dropped off the call.
Okay.
So we just have Paul only.
Okay. Paul, are you there?
Yes, Mr. Chair.
Welcome.
Thank you very much.
You have the honor of being our last item.
I absolutely love it. Thank you so much.
I don't
Paul
think-
Dacuna. I'm an architect. Sorry.
I don't think we need an extensive presentation.
Okay.
I hope that hasn't disappointed you, but
Waited all afternoon.
well, if you want to give us a brief description, we'll take that. But
Very brief.
okay,
Obviously, as you know, we had six variances at one time. We've come down to 1. It is we know that one was very palatable with planning staff because we worked diligently to bring it down to that number, and we feel we have a good application and meets the 4 tests. So through you, Mr. Chair, thank you everyone for your attention today, and we hope that you approve this. Thank you.
thank you, sir. There is no one else online. Angela is no longer there.
Correct, Mr. Chair. They were present earlier, but they have since dropped off.
Okay, so
Any
yeah,
comments?
any comments? Yeah.
Then I'm prepared to make a motion.
Okay.
I concur it is a good application and it meets the 4 tests under the Planning Act, and I move for approval with no conditions.
I'll second that.
Okay, all in favor? Unanimous approval? Yeah,
Motion
thank
to
you.
adjourn at 4:45? Is it 4:45? Somebody said
We'll take it.
we were going to be out of here by 5, so I'll take it.
Okay. Adjourned.
Adjourned.